Well, I think I'm just going to let everybody in since I can't tell if there's anybody here on this case.
Hello, Your Honor. Good morning.
Good morning.
Morning, everyone.
Morning, Your Honor.
First case up is Sains versus Fall. Is there anyone here on that matter?
Yes, Your Honor. Loretta Subi. I'm here on behalf of Dr. Fall and his PC.
Spell that, please.
S-U-B-H-I.
Thank you.
This is against the improper plaintiff that maybe.
Oh, and there she is. Okay. She hadn't shown up yet.
Okay.
So we're having trouble making the audio connection. Ms. Sains?
Yes,
Okay, I think you're here looking for additional time to hire an attorney, is that correct?
yes,
And Ms., is it Subi?
Yes, Your Honor.
You oppose this motion?
Yes, we believe that she's had sufficient time.
So Ms. Sains, what efforts have you made to find another attorney?
I have called the state bar, the lawyer bar. They gave me numbers to call another place. I've called many places. They do not return my call. I think with this COVID-19, they're not in their offices, or I just don't know what's going on. Plus, I was sick with the COVID myself for like 2 months.
So
I
ma'am,
need- I do
Go
feel
ahead.
I need extra time. I just can't get anyone to answer their phone.
I will give you an additional 30 days from today's date. My suspicion, ma'am, is the problem is with a personal injury lawsuit, once your attorney withdrew, that's a telltale sign to other attorneys that there probably isn't enough money in your case to justify the amount of time investment that they would have in it. If your case had significant value, you wouldn't have any trouble recruiting an attorney.
Well, the attorneys that I call, I don't even tell them anything about the case. They just don't return their calls.
All right, well, I'll give you an additional 30 days.
Thank you.
After that, you'll need to represent yourself.
Your Honor,
Ms. Subi, go ahead.
I do have a question because the initial stay that you put in has been lifted. We did send out requests to admit on the day that the stay lifted. So those are out and pending. So I just need to know if your stay is also staying the time period that those answers would be due.
Yes, absolutely. I want whatever attorney involved to have an opportunity to be able to respond to those requests for admission.
Okay, so she would.
Ms. Sains, you did receive a copy of the request to admit. If, under the court rules, if you don't respond to those within the time frame, which I believe is 28 days, the matters on which you were asked to make an admission are deemed admitted. And my guess is it probably means if you don't file a response to those, or if the attorney you engage doesn't file a timely response to those, it probably means your case is going to get dismissed.
Well,
So I'm sorry, Ms. Subi, you started to say something.
So they're due August 24th. So I guess we would stay them from today for 30 days. And then when that 30 days is up, the time period remaining as of today would start clicking again. Would that be accurate?
That would be accurate.
Okay, I can put that in the order then.
Okay. And Ms. Sains, you started to say something.
I guess I don't know what that was now.
All right, you'll be getting a copy of the order. I hope you're able to find someone, ma'am. Good luck to you.
Thank you very much.
Thank you.
You're welcome. Next up is Karam versus Binroth.
Good morning, Your Honor. This is our request to basically have the Jackson County Sheriff's Department release an unredacted copy
Sorry,
of
I
body
can't read
cam
it.
video.
Close all tabs. Close current tab.
Let me remove this one. Wow, that didn't work. Let's try it again. My Zoom isn't working like it's supposed to today. So I'm just looking to see, is there anyone else present on this motion? Doesn't look like it.
No, and I haven't heard from him.
I'm going to grant you motion.
I prepared an order for me approach.
I've actually got one right here. So after I sign it, you can approach and
Take it
you
downstairs so it doesn't get lost.
get to take the file with you as well. There you go. Now we got a judge's copy. We'll make sure that gets tossed. There you go.
Thank you, Judge.
You're welcome. Have a good day. Okay, next up, Rohrig versus Department of Corrections.
Morning, Your Honor.
Good morning, Your Honor.
Assistant
Morning,
Attorney
John.
General. You got the defendant. Sorry, John.
That's okay. No, it's a different world. I run into this all the time now. John Marco on behalf of the plaintiffs, Your Honor.
And who represents the defendant?
I do, Your Honor. Kendall S. Benson, Assistant Attorney General.
I heard the spelling on
ASBENSON.
That's correct, Your Honor.
And are there any parties present? It doesn't look like it.
I
Okay.
don't believe so.
And
Your Honor.
Mr. Marco, this is your motion to compel?
Yes, Your Honor. And Mr. S. Benson and I have been able to talk and coordinate over the last couple of weeks here, and every single issue is resolved except a single issue of emails. And so we just need some guidance from this court, and Mr. S. Benson has indicated, whatever the court orders, he'll be able to comply with. So this is a civil rights lawsuit, employment discrimination, retaliation suit against the Michigan Department of Corrections. As these employment cases go, which I do a lot of them, Mr. S. Benson does a lot of them, emails are critically important. Written communications that are done at the time that these things are going on before a lawsuit is being filed, and in some cases after the lawsuit has been filed. So what we've done is, because there's always tens of thousands of emails, and we always kind of have this fight, who has to go through them, what has to be produced. Mr. S. Benson and I agreed on search terms, and we agreed to limit the emails so he doesn't have to go through 20,000 and I don't have to go through 20,000 or whatever the number may be. So we've agreed on all the search terms except for 3 terms that I'm asking for that we can't agree on because he wants conditions put on those terms. And I'll tell you what they are. There's just 3. The first term is FBI, Federal Bureau of Investigation, but the acronym FBI. I want an unfettered search of that term. I believe if the term FBI, the term FBI should not be showing up in Department of Corrections communications between these individuals. And by the way, these terms are only with regards to the identified individuals. So it's not anyone at the department. We've identified 5 or 6 relevant people who I'm asking for the term FBI from. Mr. As Benson wants the term FBI to only be produced if it includes one of my client's names. And I think that would be unfairly limited. I also think it's discoverable if, and we could miss things. So if there can't be that many times where in the last years that these identified individuals are using the term FBI in their emails. So I'm asking for any emails that contain the word FBI. And the reason that that's really important in this case, Judge, is because part of the complaint is that my client reported illegal activity to the FBI. And as a result, he was retaliated against at the Department of Corrections. So that's very important. The second search term that we can't agree on is the word whore. That's W-H-O-R-E. The reason that that's important is because one of my clients filed a complaint on a supervisor who had called another female employee a whore at the facility, and we believe she was retaliated against because of that. She filed a formal investigation request over the use of this term, which could be sexual harassment. Now, again, Your Honor, same with the FBI. There shouldn't be that many times, conceivably, and I would hope that these individuals are using the word W-H-O-R-E in their email communications with each other on work computers. So I don't want any limitations from these individuals if they've used that word in their emails. Brother counsel's asking that the word only be produced if it includes my client's name in the email as well. But that raises other problems because it's not just my client in relation to the use of this word. It's if she used the word towards anyone. So if they're discussing it, we're just requesting those emails. And finally, the third request is any emails that contain my name in the email. Again, I would hope that there's not that many emails that contain the name Marco, but certainly if there's a non-privileged email where they're discussing the lawsuit in between individuals, that would be discoverable and that would be relevant. And this is just for discovery stages. So the 3 words that I'm asking for, FBI from these identified individuals, the word whore from these identified individuals, and the word Marco from these identified individuals. And with that, Your Honor, those are the only outstanding issues. We've agreed on all the other issues and we're working together.
Thank
Your Honor,
you.
with regard to these
Atkinson?
3, thank you, Your Honor. With regard to these 3 terms, searching the terms individually by themselves produces more hits than all of the other searches combined. There's over 4,200 items, which means, that doesn't count necessarily, that doesn't count the attachments to the emails and so forth. So we're looking at, at least another 80 hours of redactions and document review, in addition to the roughly, 75 hours for the initial search that we've all agreed to. But just searching these 3 terms without limitations, we're looking at additional at least 80 hours of my time to go through all of these emails. And it's just not proportional to the case.
So let me stop you for a minute. If I understand you correctly, you've already done a initial search to see how many times each of these terms shows up. And it's yielded how many times for FBI?
Approximately 4,200. Well, for those 3 searches combined, it's 4,200. hits. And that's, that's approximate. It's not exactly precise. It's hard to do that when there are more emails and stuff going into inboxes every day. But when we ran the search, it was the difference was approximately 4,200.
And how many individuals' emails are being searched to produce that number of hits?
I believe it's 7. And so, Your Honor, with the new rules, go ahead.
Do you have the breakdown of how many hits for each term individually?
I can probably get that. The court will indulge me for a moment.
Sure.
With the term FBI, we're looking at, if we search that just all by itself, 3,487 hits or items. And the term Marco, we're looking at roughly 560. And the term horror, 360, or excuse me, 260.
So obviously, Mr. Marco, based upon these numbers, your theory that the term FBI can't possibly appear very many times.
We're a law enforcement agency. We talk.
I stand corrected. How about a proposal of compromise that I would be willing to entertain if the court would? My proposal because I didn't have these numbers before. My proposal of compromise would be the horror term be produced. That's 260. That's more than I thought, to be honest, but I think certainly I want to look at those given this case. Marco, again, 560. I certainly want to look at those if they're talking about this case. And it's non-privileged, of course. I'm not asking for privileged documents. If they're talking to their attorney, of course, I'm not requesting those. And he can produce a privilege log. On FBI, I will qualify it. If there's an agreement on this, on the others, that I will adopt Mr. S. Benson's proposal, which is FBI combined with either name of the plaintiff. So FBI and Warrig or FBI and McCabe, I would adopt as a compromise position if the others are turned over that position.
With regard to the term Marco, Mr. Marco joined this, doesn't have involvement while the claims are actually being, he doesn't have involvement in the discipline process and so forth. His name's going to come up after there has been litigation filed, if at all. And I'm fairly confident that most of that is going to be privileged emails, responding to his discovery requests or things along those lines. I think we need to limit this to this case. Mr. Marco's a repeat player here with MDOC. We don't need to be looking at all of the emails. I think there's a reasonable limitation placed on his name. We don't need to go on a fishing expedition to just see how many times these 7 individuals actually mention Marco's name. If it's going to be relevant, it's going to have one of his clients' names in there too.
Judge, the test is not relevancy. The test is discoverability. Even under the new court rules, I'm not asking for any privileged information, and by defense counsel's own admission, there's a very limited amount of time. I should also note that this case is not a termination case where the case stopped when we filed the lawsuit. Okay, so it's not like bad things happened, lawsuit was filed, and the case is just this finite period of time. This case is still going on. They are still working there. They are still suffering from treatment of the employer. So the relevant time period is today, and then it's going to be tomorrow, and it's going to be into the future. So I don't think the argument that there's an artificial cutoff is very convincing here.
I understood the cutoff being the starting point. So whenever it was you first got involved, prior to that, prior to you having any involvement on behalf of either of the plaintiff, the fact that your name shows up in an email, what value could that have?
It could certainly have value because I've deposed these people before. I've tried cases against them before. I've cross-examined them in court before. If they're talking about, for example, let me give you an example. There was discriminatory harassment complaints that were filed in this case. Discriminatory harassment complaints trigger an investigation. That investigation goes to Stephen Marshke, okay? If Stephen Marshke's using my name, discussing the client's discriminatory harassment complaints in any capacity, I want to see it, as long as it's not privileged. If it's to an attorney, I don't have a right to that. But if he's discussing my name, how conceivably could he be doing that? It could happen prior because Mr. Marshke knows that I often am involved at discriminatory harassment stage. I'm often involved before the lawsuit is filed. I often attend grievance hearings. I'm intimately involved in the whole process for employee complaints from the beginning till the end. So I don't think it would be fair. If they want to argue whether it's relevant in a motion in limine later, that's fine. But Judge, we're only talking about just over 500 emails here. So, I mean, what's the harm in discovering it? And we already agreed to a protective order. There's a protective order in place in this case to protect all the parties, which I agreed to as a compromise and as a way so we could just streamline this process. If we were talking about 25,000 emails or something, I don't think I would have a good leg to stand on here. But we're talking about such a small amount of emails that they can easily be produced, and then we can argue about their admissibility later. I mean, you're going to make a decision on that before we have a trial in this case. Let's just see what they said and see how, why in the world would they be using a plaintiff's attorney's name who is well known through personal experiences of their own, and I mean personal, in the courtroom, mano a mano, across from each other, on a case like this.
Well, and Your Honor, I think that's an excellent argument for why this is a fishing expedition. Mr. Marco just wants to see what folks over at MDOC are talking about him, just generally. And we're going to get this discovery request in every single case that he files, and he doesn't file. He's not an infrequent filer against us. There's nothing that would be relevant before he gets involved with this case. So I think Your Honor wisely pointed out that a time frame of when Mr. Marco gets involved narrows this to more relevant and potentially discoverable information, as opposed to, let's just see what they said about me, which is basically what Brother Counsel's argument just amounted to.
Judge, I have a pretty good idea what they say about me behind closed doors, and I have thick skin. I've been doing this long enough. I'm okay with that. In fact, Mr. Marshke
that's my point, John. You want to see what they're saying.
Mr. Marshke
that doesn't have anything to do with your case.
Mr. Marshke has told me to my face what he thinks about me. I'm not worried about that. But certainly, if they're talking about anything else, we need to see it. And the filter is a motion in limine. That's the filter. And you're going to act as a filter, Your Honor. You're going to act as a filter. We just want to get the documents. We can't let defense counsel ascertain what's relevant or not. You're going to do that as the gatekeeper of evidence in this trial. And like I said, there's protective order.
All right, I think that Mr. Marco's proposal is a fair one. All instances of Hoare and Marco with the 7 individuals needs to be produced unless privileged. And any occurrence of FBI with either or both of the plaintiff's last name needs to be produced. Mr. Marco, you prepare that order?
And Your Honor.
Yes, Your Honor. And Your Honor, just real quick, we have a joint request. We've talked, and if this court would indulge us very briefly, with regard to scheduling, as you know, COVID-19 has, I don't know if you know, but it has particularly hit the prison system very hard. Mr. S. Benson's been on furlough many, many days. That has further slowed down this case. It's also prevented us from taking live depositions, which is our preferred method. And with these discovery issues, we have literally been able to do, other than written discovery, nothing. And so, and you know, Judge, I like to move my cases as quickly as possible, but under the circumstances, I've talked to Mr. Benson, we're in agreement, would ask that the court reset the scheduling order dates to allow us time. There's like 7 named defendants in this case. They're all gonna have to be deposed. They're all over the state of Michigan. We have tens of thousands of documents that we're gonna have to go through. We're making a joint request to reset the scheduling order dates.
I've got no problem with that. However, I'm not going to let you wait to do live depositions. Video with good quality video is good enough. So don't wait on those, but otherwise I'm willing to grant you whatever extension the 2 of you can agree on.
All right.
If you could put it in a proposed order with the existing dates stated and then blanks for the proposed dates. And then with your cover letter indicate how much you want me to push them out. We're still so far away from doing a civil jury trial that I'm willing to give, you know, whatever reasonable time you folks can come up with.
Thank you, Judge, and we'll work together. Mr. Benson, S. Benson and I have the unique luxury of 2 people on the other side with the MDOC to work pretty well together. So we'll work together to get that submitted.
And Your Honor,
Very good.
was Jonathan's name supposed to be limited in time at all? The search for
No,
Jonathan?
No limit. The only limit is the 7 individuals.
All right.
Thank you, Your Honor. Have a great day.
Thank you, gentlemen. Okay, next up is Kaid versus Craze. Anybody here on that matter? Looks like it must have gotten resolved. Next up is Holscheider versus Bush.
Good morning,
Morning, Your Honor.
Allison, I'm sorry, losing my voice a little bit today. Allison Lizette on behalf of the defendants.
Last name is Lizette, L-A-Z-E-T-T-E, and Mr. Marienfeld for the plaintiff.
Correct.
Your Honor, this is our,
And this motion to withdraw.
I believe, Your Honor, Ms. Lizette has a motion to enforce the settlement, which, to save her voice a little, I will add that I completely concur with it. We did, based on the authority that I thought I had, we settled the case over the phone. We had discussions, confirmed it in email. She sent me a release. A couple of issues came up. Mr. and Mrs. Holscheider did not, and I'll let them speak for themselves, obviously, but they didn't like the language in the release that said there was no admission of liability, which frankly is standard in every single release I've ever executed. Then the second issue that arose was that they were not happy with the prosecutor county prosecutor who may or may not have chose to prosecute the defendant in this case criminally for the same action. As you know, that's completely out of my control, has nothing to do with this civil case. I was acting on my authority to basically make them whole. We searched it out, got the cost for the stump removal to get the property back where it was, had an expert to put a value on the trees, put a number together, and then they frankly didn't want to follow. So I would ask simply that either one, you enforce a settlement. I think Ms. Lizette had to rely on what would be discussed, or if you can't, we'd never get a case resolved. Or two, if you are going to allow the Holshiders to go forward and have their day in court, so to speak, I would ask that you let me withdraw because it's definitely broken down between us. But that's my position, Your Honor, and I would defer.
I concur with everything he just said. I'm sure you've read the motion, the pleadings. We confirmed the settlement in writing. I cited the case law that says that we do have a settlement that this court should be enforced. I do need the language in the release that said that there's no admission of liability. And if this matter is separately, something action is taken on it criminally, then that's a whole separate matter, as this court is well aware.
Thank you. Mr. and Mrs. Holscheider, I guess I don't understand what your objection is to this release language.
Well, at this point, we were talking with the prosecutor and talking with Ron. We were under the understanding that nothing had happened yet. We weren't really aware of what was happening until June 10th. So that's why the long gap in our response was. At this point, we are under the understanding that we are going to go forth with the settlement.
Oh, very good. That resolves everything. You're willing to sign the documents and return them?
Correct.
Okay, very good. I think that's a wise choice.
Is that what we're doing?
Yeah, now by signing this, it means that Chelsea Guernsey cannot go on with the action she's taken? Or
I don't know
wants-
anything about that.
This is, and Judge, maybe I can help. I think there's some confusion in just on their behalf, or to help them understand better. This civil case is completely separate from the criminal case. The prosecutor's office can do whatever they'd like, no matter how this case goes. And nobody here really has any control over that. So that was what I'm trying to explain, and hopefully that makes sense.
Okay, so what you put in the contract there does not affect Chelsea what's her name? Chelsea
The prosecutor.
Guernsey. Doesn't affect what she's already done at all.
Correct.
Okay.
Stay away.
Oh,
Okay.
The other thing we were hoping that you would have put in the contract was a clause that the property isn't a restraining order, but it's just a stay away order from the properties. We own 4 properties up there, and truthfully, our granddaughter's afraid to go up there anymore for fear of all of a sudden Mr. Bush will be there, and she's frightened.
That's something you're gonna have to take up in the criminal action. This is just civil, which means it's only about money.
Okay.
Definitely talk to Ms. Guernsey about that.
Okay.
Okay. Sounds like we're all resolved then?
So.
We are. I'll just look for the release.
And can I enter an order saying our motion's granted and the documents will be
Yes.
forthcoming within 30 days?
Yes, you may.
All right.
Okay, thank you all.
You're on.
Thank you.
I have an 11 o'clock. Should I just get off and get back on?
Yeah, just come back on.
Thank you.
And the $6,500 payment settlement.
Our office,
Can there be a timeline put on that so that we're not doing this until next year?
I already have,
Soon as you get me that release, I will get it to Ms. Lizette the same day.
I already have the check. My office has the check. So once you get me the release, I'll mail you the check. I'll mail the check to your attorney, okay?
Okay. And this release then will also go to Ron, the way it was originally done?
Yes, absolutely. Send it right through me and I'll get it to the other attorney, the exact same terms we discussed before.
Okay. That'll be sent today.
Thank you.
Thank you. Have a good day, folks.
Thank you.
Thank you.
Yeah.
Estate of Rosetta Dismukes versus American Mortgage. Is that what that is?
Ameriquest, yes. Judge, and I represent Ms. Beatty, who is the personal representative in the probate matter.
Okay, and she is present on Zoom.
She is, Judge. And Judge, this is a matter where a default was entered against Ameriquest. They held a mortgage that had not been paid for an extended period of time when Ms. Dismukes was still alive. No action had been taken. As near as we can tell, Ameriquest is now defunct. We have contacted every mortgage company that we can identify that purchased any mortgages from Ameriquest, none of whom have purchased this mortgage. American Title ran a search, did not find anything else. I have a copy of that American Title work for the court. We're asking that the court enter a judgment quieting title with respect to this mortgage.
And I will grant that judgment. What's the date of the mortgage?
The mortgage was recorded February 9th of 2006.
Oh, okay, so fairly recent.
Does the court want to see the American Title work?
No, I don't need to
Okay.
see it. I was just, I know there's a title standard that talks about old mortgages. They wouldn't encompass something this recent.
Because of we would have just waited, I think it's a couple more years, Judge, but because of the probate matter pending, Judge Rapley was not interested in us continuing to just kind of let this house fall to disrepair. So Ms. Beatty, I'll be in touch with you. The judge is signing our order so that we can file that with the Register of Deeds, and then we'll have that title cleared from the mortgage, okay?
Yes, thank you.
Thank you. I can take that down. Thank you, Judge.
Thank you, Susan. Have a good day, Ms. Beatty.
You too, thank you.
You're welcome. So that, the attorney that was on said she's got another matter at 11?
And Judge,
Oh, I see it. It's an ADR conference. That's strange.
and we've got Grappentine again at 1 o'clock?
Yes.
And Ms. Peen has indicated she's going to ask the court to withdraw. Ms. Grappentine has indicated, again, she's going to be firing her lawyer. I'm not entirely sure what will be happening at 1.
Not likely to keep me on the bench all afternoon, though.
My expectation would be no, Judge, and I plan to appear by Zoom if that's convenient for the court.
Oh, yeah, I like Zoom.
I thought you might.
Then I can mute lawyers that are talking too much. That never you.
I'll try and behave. Thank you, Judge.
And I won't mention any other names.
Have a good rest of your morning.
You too.